right. I've opened the record in the matter of Gianna McKim, case number 2020-2262-DL. My name is Marc Crotteau. I'm a referee with the 37th Circuit Court. Because this matter is being heard by a referee, any party has the right to file an objection, asking the judge to review any findings or recommendations that come out of today's hearing. Anyone choosing to do that has to do it within 7 days in accordance with the court rules. Present for today's hearing by Zoom is Gianna McKim. Is that correct?
Yes.
And Gianna is on the same Zoom call as her mother, Janice. Is that correct, ma'am?
Yes.
I'll note that prior to starting today's record, I put Gianna and Ms. Huffman, her attorney, in a breakout room so they could have a discussion. Ms. Huffman, are you and your client ready to proceed right now?
We are.
I'll note that we also have Ms. Russell here from Family Court Probation, and we have Ms. Kilgore here from the MST program. We're here today for a probation violation hearing in this matter. Let me ask, Ms. Huffman, are we ready to go forward right now?
I'm sorry. If you were talking to me, I couldn't hear you.
Okay, are we ready to proceed right now?
Yes, we are.
My understanding is that there is an agreement as to how to proceed today. Is that correct?
Yes, there is.
Will you
My
put that on the
client-
record for us, please?
Certainly. My client would be admitting to number 1 and 2 violating of her probation, which is vaping on the bus and was suspended from school, and vaping at home and refusing to give the vape to her mother. Those are 1 and 2. And then she would be spending April 2nd to the 11th in the juvenile home. And parents would be responsible for the cost and care. And we would have a review hearing in 45 days. That's my understanding.
All right. So, Ms. Russell, is that an agreement that you would be willing to go along with?
Yes, it is.
All right, and just to make sure I have it right then, it's admitting to paragraphs 1 and 2 of the petition, and that the disposition would be that she would spend April 4 through 11 in the juvenile home. That's essentially spring break, I'm guessing.
Yes.
And then another review hearing would be set in approximately 45 days.
That is correct.
Okay. Gianna, let me ask you, did you hear the agreement that the two lawyers, or pardon me, that Ms. Huffman and Ms. Russell just put on the record?
Yes.
Is that what you're willing to agree to?
Yes.
Let me ask the McKims. Looks like I see Mr. McKim there, and I know Ms. McKim was present earlier. Does that seem like a good idea for your daughter?
I think it'd be a good idea. There's some consequences to her actions, but I don't understand why we're responsible for the cost.
All right, and I will note that that is essentially something by statute and by local rule. I will tell you that if you don't think that's appropriate, you certainly have the right to file an objection to my order and get that matter up in front of judge and discuss it with judge, or file a motion and get the matter up in front of judge. Either way, it would be judge that would be making a decision about if you should not, I guess it would, how to say it, it would have to be judge making a decision not to assess costs to you.
Okay. All right. I understand that.
Okay. Gianna, let me ask you to please raise your right hand.
Yeah, he's talking to you.
Do you swear or affirm that the testimony you're about to give will be the truth and nothing but the truth?
Yes.
Thank you. You can lower your hand. Please state your name and your date of birth.
Gianna McKim, September 14th of 05.
Okay. So Gianna, I need you to understand that by proceeding with this agreement, you would be giving up the right to have this probation violation decided by a hearing. If we were going to have a hearing, what would happen is Ms. Russell would have to present witnesses and evidence to try to convince me that you were in violation of the rules of probation. She'd have to do that by a preponderance of the evidence. If she couldn't do it, then that would be the end of the matter. The violation would be dismissed. On the other hand, if she could, then you could be subject to any disposition that's allowed under the juvenile code. It could be me warning you not to do it again and dismissing the matter. It could be you being placed in the juvenile home or some other out-of-home placement, or it could be anything in between. If we have a hearing, Ms. Huffman would get to cross-examine the witnesses, if you recall. Ms. Huffman would get to present witnesses and evidence in your defense if the two of you thought that was a good idea. And Ms. Huffman could use the court's subpoena power to compel a witness to come to court if there was a witness you wanted to call who didn't want to come and testify. You would have the right to testify in your own defense if you chose to, but you wouldn't have the right to remain silent the same way you would in a criminal matter, because a probation violation is not technically a criminal matter. Do you have any questions about those rights, Dale?
No.
You understand that by proceeding with this agreement, you would be giving up those rights?
Yes.
Is that still what you want to do?
Yes.
Then let me ask you, Jayana, were you placed on probation
Yes.
on February 22nd of this year? Were you suspended from school for vaping on the school bus?
Yes.
On March 5th of this year, were you caught vaping at home and refused to give the vape to your mother?
Yes.
And again, did those things happen while you were on probation?
Yes.
Ms. Huffman, with regard to qualifying your client for those admissions and the factual basis for the violations, are you satisfied?
I am.
Ms. Russell, are you satisfied?
I am.
All right. I will note then that based on that, I do find that Jayana is in violation of the rules of probation by a preponderance of the evidence. The agreement that has been reached does strike me as reasonable based on my knowledge of the history of this case. Jayana, is there anything else you want to tell me before we do that disposition?
What?
Is there anything else you want to tell me?
No.
Mr. McKim, anything you want to tell me just now?
No, that's my only question.
Ms. Huffman, anything else from your standpoint?
Nothing further, thank you.
Ms. Kilgore, is there anything from the MST standpoint or MST program standpoint that I should be aware of?
No, there's not.
And last but not least, Ms. Russell, anything from your standpoint?
No, thank you.
All right, then I will note that we will do disposition as per the agreement. Jayana will be remanded to the Calhoun County Juvenile Home from April 4th through 11th. And we will set a review hearing in approximately 45 days after she is released. I don't know the exact date. My staff will have to send that out
Second.
to parties in the mail once they have had a chance to pull that date.
I thought it was April 2nd to the
Yes.
11th.
Yes.
I'm sorry, April 2nd to the 11th? Okay.
Yes, it is.
I typed 4th, and that's probably my typo. April 2nd through 11th. And I'll note then that the parents, the McKims, will be responsible for the transportation to and from the juvenile home. I will call the juvenile home and let them know. Actually, Ms. Russell, is there a particular time that Jayana should be dropped off and picked up by from your standpoint?
Probably, I would say no later than 6 o'clock on April 2nd.
6 p.m.?
Yes.
Okay.
And
So I will
then,
tell, go ahead.
and then as far as picking her up on April 11th, the parents will need to contact the juvenile home to set up a time to do that.
Okay. I'll let the juvenile home know then that 6 p.m. is the anticipated time. Let me see.
Does it need to be at 6 or just prior to 6?
It'll be no later than 6 p.m. Whatever is convenient from your schedule standpoint in that general time frame.
Okay, thank you.
All right. Jayana, do you have any other questions for today?
No.
For the McKims, any other questions from your standpoint for today?
No.
No.
Ms. Huffman, anything else?
No, nothing further.
Ms. Kilgore, anything else we need to address?
No, thank you.
And Ms. Russell?
No, thank you.
Folks, I will remind you that you have 7 days to file an objection if you want the judge to